Mane fa na se ma PENDREAM TV. PENDREAM TV de osia dem yopo.
You are once again welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell for more updates, like and also share to other members to watch as well. You can also leave a comment after watching or send us a voice note on our WhatsApp number showing on your screen as well. Thank you. Please, today I want you to join me listening to what a former judge of the Supreme Court have to say or has in a reaction to the behavior of the Supreme Court against the proceedings of Parliament. And that person is nobody but Williams Atuguba. Thank you.
Let's move on this particular story. William Atuguba is former Justice of the Supreme Court, and he joins us via Zoom to help us appreciate the happenings in Parliament and the Supreme Court over the past few days. I'm grateful to you, for retired Justice, for joining us here. Now, with the service of the Supreme Court processes on the Speaker, what does it, do to the makeup of the House?
You see, the effect of the service. You're asking the effect of the
service. So yeah, once the service has been done on the Speaker and he has acknowledged that, what does it do to the makeup of the House?
The makeup of the House, in what terms? So,
I mean, both sides are claiming majority. With the Supreme Court processes being served on the Speaker, who forms majority now?
Well, in the first place, I don't know whether that's not a quasi-moot matter because Parliament is not sitting. It's Johnson and I. And quorum will arise if the party is the Parliament is sitting. Nonetheless, as a legal question, court orders take effect according to their terms. When a court order is made, it's to be obeyed according to its terms, unless it's set aside.
Okay.
And so, at first, it was a deep-seated principle of the common law that if an act is null and void, it is automatically null and void. You don't even need court process. But later, there was a vote fast, probably on grounds of public policy, peace, and that kind of thing. And particularly in Ghana, it was said that notwithstanding the nullity of any court process, you can't disregard it. Your only way is to go and have it set aside. That's how to extricate yourself from its effect.
Okay. Now, I mean, you see what's happening now. In terms of your understanding of Article 97G and H, how should we really understand it? Is it applicable in the current Parliament, or as some people say, in future Parliament? Help us understand.
Yeah, I must confess that originally, when this matter arose, and I read those provisions, I thought they will relate to somebody, if somebody is contesting towards election into the next Parliament, that this provision will not hold him as having crossed carpet. But I must confess that when I thought of it over and over again, and particularly the terms of the reasoning of the Speaker was pronouncing on this matter, and even having regard to the realistic practice of the parties themselves. We all know of Michael Quest time. You know what happened there?
Yeah.
Yes. And so, you see, politics aside, always, when things are settled, and that's my trouble with politicians. Things are hardly settled. They are settled in one way when it is in their favor, they are happy with it. When it goes against them, they try to unsettle it by all means. These days, when people are talking law, I feel that we have to distinguish between political law and actual law. Political law is jaundiced law, in my view, sometimes. They try to tilt legal reasoning towards their political interests. That's just an aside. But I think that, as I said at first, I thought if a member of parliament is running for election to the next parliament, the idea is that his new membership will take effect with the next parliament. And that will show his definitive break or otherwise with his party. But having listened carefully to the reasoning of the speaker and even the practice of it was the MPP that
Well, we're still on with Justice retired William Atuguba. Okay.
To say that the member.
Well, this is still prime. We are talking to Justice retired William Atuguba. He is a retired justice of the Supreme Court of Ghana, trying to make sense of what happened in Parliament. Okay, so let's go over to him now. So you were making a point about what your understanding is of Article 97 H and G, because that is the basis of the controversy. So we want to understand, what's your understanding of that provision?
Yeah, as I said initially, I thought if a member was running in the current campaigns as an independent of his party, to become independent in the next parliament. That's how I understood. His independence would be effective as from the next parliament if he got into that parliament as an independent candidate. But having listened carefully to the reasoning of the speaker and the president at Michael Quest's time, and the party's own understanding of what amounts to leaving their fold, I think that it will be incongruous to say that when a person is campaigning as an independent candidate from his party, he can be said not to have left his party, crossed carpet, as it were. After all, crossing carpet is related to either coming in as a member of a particular party, and then you leave it and join another party, or seeking to remain in parliament as an independent candidate after having been elected on a particular party's ticket.
Okay.
So, I mean, it is incongruous to say that when a party, a member decides to run independently for parliament, he has not yet crossed carpet. Okay. I mean, he is there in the open battling his own party.
Now, with that foundation, made, what then do you make of the ruling by the Supreme Court, staying the ruling that the Speaker gave, pending the hearing of the substantive case?
Yeah, well, I wouldn't have gone in for a stay because stay normally will relate to court judgments and so forth. If the order is not emanating from the court, your powers of stay do not relate to it. What they can do is to issue an injunction in respect of whatever has been done.
Okay.
A stay of execution. Stay of execution relates to execution by resort to court processes. That's what execution is in law.
So the Supreme Court erred in that?
Well, I'm coming. Technically, those days of strict technical law, yes. But as time went on, the courts took the view that, I mean, if you don't just stick to the letter of the application, slavishly, if it can otherwise be justified, on some other ground, it can hold. So, because there are instances when a party takes a step, the court finds that it's faulty, and they say, "Oh, we'll treat it as another step, which is more regular." You understand what I'm saying?
Mm-hmm.
If there is a more regular step the party could have taken, but he takes a wrong step, the court can treat it as if he had taken the better step and entertain it. In other words, they will cure the lapse of the suitor. And so sticking to particular expressions of legal terms will not necessarily carry a person the way he wants. But the courts are out for substantial justice. Even statutes, originally statutes, according to British common law, were to be construed strictly. There's nobody who hold that view. They look at the purpose, the spirit of the law. But originally, I mean, it was settled that once the wording of the statute was clear, that ended it, no matter the consequences and whatnot. But over the years, they tried to water down the rigidity of that principle. Currently, it's the purposive principle of interpretation that prevails. So
do you agree with people who said the Supreme Court, erred in taking up this matter, that they shouldn't have sat on this matter, and you even alluded to that this was not a ruling, and therefore a ruling of the court, and so staying it wasn't what should have happened?
Well, I think that the proper step would have been to go to the High Court, because specifically Article 90, let me read it, 97(1). A member of Parliament shall vacate his seat in Parliament. All kinds of situations. Then it gets down to F. If he resigns, from office as a member of parliament by writing under his hand address to the speaker, or G, if he leaves the party of which he was a member at the time of his election to parliament, to join another party, or seeks to remain in parliament as an independent member. This is the kind of vacation of office that's involved in this matter, not so?
Yeah.
All right. Now, it goes on to Article 99, 1. All right, let me read it. It's a short provision. 99.1. The High Court shall have jurisdiction to hear and determine any question whether A, the person has been validly elected as a member of parliament, or the seat of a member has become vacant. Okay? Yeah. So, the question of vacancy of parliamentary office is given to the High Court, not given to the Supreme Court.
Well, but the argument people put up is that this has to do with interpretation of the Article 97G and H, and that's why the Supreme Court is clothed with the authority to do that.
You see, that's why sometimes there's a need to be very, very careful in handling constitutional matters, matters of interpretation. It's a very tricky and involved matter. Yes, the Supreme Court has exclusive jurisdiction in the interpretation and enforcement of the Constitution. Nonetheless, the Supreme Court from the beginning held that where the provision is clear and unambiguous, there's nothing to interpret. So if a matter arises in any court, it can even be a district court, the lowest, once it's clear, they can go ahead and apply. In that case, they are applying the Constitution, not even they carry it to enforcement. Okay. So the mere fact that a constitutional provision comes up does not necessarily mean the Supreme Court has original jurisdiction. This original jurisdiction is widely couched. Articles 2 and 130, these are very widely couched. But we all know it's a worn-out principle of statutory construction or constitutional interpretation. You don't read the provisions of any statute or constitution or even any document for that matter in isolation. You read them holistically because they interact with each other. Without stating so in express terms, you will find that a blanket statement in the commencement of a provision is watered down by a subsequent provision without even reference to it. But the effect of the second provision cannot be ignored. And if it is a bit inconsistent, unless the inconsistency is such that it cannot be countenanced. But otherwise, it will have to be read as an exception to the general provision, you see. So, and even Article 130, which gives the Supreme Court its jurisdiction, this is your question about the question of interpretation is involved. It solves it. It does not deprive the lower court of its jurisdiction. What it says is, if it happens so, in the case that is commenced in the lower court, let's say they have jurisdiction relating to the subject matter, but a question of interpretation arises, they will stay the proceedings and refer the matter which calls for interpretation to the Supreme Court. And stay the proceedings until they receive the interpretation from the Supreme Court and decide it otherwise. So you'll find that the Supreme Court, that's the remedy given to an interpretation issue arising out of a matter that is within the jurisdiction of a lower court. I can read it out to you, 130. 130. Yes. 131. Subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution, and B, all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person or by law or under this Constitution. Now, 2, where an issue that relates to a matter or question referred to in clause 1 of this article arises in any proceedings in the court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. In the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. So, quite clearly, it doesn't deprive the lower court of its jurisdiction over a matter that involves interpretation before it. It says stay the proceedings and refer that matter to the Supreme Court.
Okay, all right. From where you sit as a statesman, how should this case be resolved so that Parliament can go about doing it, performing its duties the way it is expected to?
Is it?
I said, from where you sit
as a case.
Yes. How should this case be resolved? Because now Parliament has been adjourned indefinitely because of this. How should it be resolved?
Well, the matter is before the Supreme Court, and I'm sitting on it. I can't tell them what to do in it.
Okay.
So we're waiting for how they'll resolve it.
All right. I'm grateful to you for spending your time this evening to help us appreciate what's happening and what the law really says. That's Justice retired William Atuguba, a retired Justice of the Supreme Court of Ghana. We'll take a break here on Prime. We'll be back with more, please. Don't go away.
Thank you for staying tuned. PENDREAM TV really appreciate your time. Please, if you have not yet subscribed to the channel, please do so for us. Hit the notification bell for more updates. Like and also share to other members to watch as well. You can also leave a comment after watching. Thank you.
PENDREAM TV now, so far so good. Say open online portal Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.